My neighbor sued me for $750,000 over a bird feeder. What the judge said left the courtroom speechless. The bird feeder in my backyard has been there since Bill Clinton's first term. My husband Roy hung it on the oak branch the year after we bought the house. A simple cedar platform with a little roof to keep the rain off the seed. I've refilled it every Sunday morning for 30 years. Chickadees, cardinals, sparrows, the occasional blue jay. It's the first thing I see from my kitchen window while the coffee brews. Roy passed in 2019. I kept filling the feeder every Sunday because some routines are too important to let go of. I never imagined someone would try to sue me over it. Dennis Moyer moved in next door in the spring of last year. He'd bought the house from the Petersons, who'd been quiet neighbors for 2 decades. Dennis was not quiet. Within his first week, he'd complained about my wind chime, the height of my back fence, and the condition of my side garden, which he said was attracting vermin. 3, he knocked on my door to tell me that my bird feeder was attracting crows, and that the crows were defecating on his property. He wanted me to take it down. I told him politely that the feeder had been there 30 years and that crows go where they please. He stood on my porch for a moment, then walked away without saying goodbye. 2 weeks later, I found a typed letter in my mailbox. Not mailed, hand-delivered. It was from Dennis, and it outlined his formal objections to the bird feeder. He claimed the crows had scratched his car. He claimed bird droppings had damaged his patio furniture. He claimed the noise from the birds was affecting his ability to work from home. He demanded I remove the feeder within 14 days. I read it at my kitchen table while a chickadee pecked at sunflower seeds outside the window. I put the letter in my recycling bin. 2 weeks later, another one arrived. This time, it mentioned lawyers. The next letter wasn't from Dennis. It was from the law offices of Richard Bellamy III, Esquire. It informed me that my negligent maintenance of a wildlife attractant had caused significant property damage and emotional distress to his client, and that if I did not remove the bird feeder within 30 days, legal action would follow. I read it 3 times because I genuinely couldn't tell if it was real. A wildlife attractant. That's what they called my bird feeder, the little cedar thing with the pointy roof that Roy made. I called my friend Helen, who's a retired paralegal. She laughed so hard, she started coughing. Then she said I should probably find a lawyer anyway, just in case. The formal lawsuit arrived 6 weeks later. Dennis Moyer was suing me, personally, Judith Hoffman, age 67, for $750,000. The complaint alleged property damage, emotional distress, loss of enjoyment of his home, and something called continuing nuisance, all because of birds. I sat with that number for a long time. $750,000. My house was worth less than that. My entire retirement savings were less than that. This man wanted to bankrupt me over crows eating sunflower seeds in a tree that was on my property. I wasn't laughing anymore. I couldn't afford a private attorney. Not for something this size. My pension and Roy's survivor benefits covered my bills and groceries with a little left for the granddaughters' birthdays. I went to the county legal aid office and explained my situation to a woman at the front desk who looked like she'd heard everything until I told her the amount and the reason. Her eyebrows went somewhere near her hairline. They assigned me Angela Chen, a staff attorney who was maybe 30 and had an energy about her that made me think of a terrier on a scent. She read the complaint in my presence, looked up at me, and said, "This is the most ridiculous thing I've read this month, and I read a lot of ridiculous things." Angela requested Dennis's evidence through discovery. What came back was, I'll give him this, thorough. He had a 3-ring binder of dated photographs showing bird droppings on his car, his patio, and his outdoor furniture. He had a log of crow incidents going back 8 months with times, descriptions, and estimated cleanup costs. He had receipts for 3 car washes, a patio power washing, and a replacement cushion for an outdoor chair. The total documented property damage came to $340. $340. He was suing for $750,000. Dennis's complaint included a letter from his therapist stating he was experiencing anxiety and hypervigilance related to the crows. He claimed he couldn't use his backyard without fear of being dive-bombed. He claimed the noise disrupted his work-from-home schedule. He claimed he'd developed an aversion to looking out his own windows. Angela read me the best part out loud. Dennis had included a personal statement saying that the crows had fundamentally altered his relationship with the outdoors and that he now associated the sound of birdsong with dread. I wanted to feel bad for him. I really did. But the man was trying to take my house over a bird feeder. Angela filed a motion to dismiss for failure to state a claim. Her argument was simple. Feeding birds on your own property is not a nuisance under state law. Crows are wild animals that go where they please. A property owner has no duty to prevent wild birds from flying over a neighbor's yard. The claimed damages were speculative and absurd. Dennis' lawyer, Richard Bellamy III, opposed the motion. He cited a case from 1987 about a pig farm. Angela told me she almost fell out of her chair when she read his brief. "He's comparing your bird feeder to a pig farm," she said. "I cannot wait to argue this in front of a judge." To everyone's surprise, Angela's included, the judge denied the motion to dismiss. He said that while the claim seemed unusual, nuisance law was fact-specific, and the case should proceed to allow both sides to present evidence. Angela was annoyed, but not worried. "He wants to see the 3-ring binder," she said. "Fine. So does the jury." The case was set for trial. Dennis Moyer versus Judith Hoffman. $750,000 over a bird feeder. When my granddaughter heard, she asked if it would be on Judge Judy. I told her real court was less entertaining. I was wrong about that. Dennis showed up to trial in a three-piece suit and what I'm fairly certain was a new haircut. His lawyer, Bellamy, wore a bow tie and carried a leather briefcase that probably cost more than my monthly pension check. They set up at the plaintiff's table with binders and folders and a laptop and acted like this was a murder trial. I wore my good cardigan, the green one with the buttons. Angela had her legal aid binder and a single folder of documents. We looked like we'd wandered into the wrong courtroom. But Angela had told me not to worry. Let them put on a show, she said. Shows are easier to knock down than arguments. Dennis took the stand and talked for 2 hours. He described the crows in detail that bordered on obsessive, their size, their call patterns, their aggressive territorial behavior. He described scrubbing droppings off his car at least twice weekly. He described his fear of using his own patio. He described a crow that he swore stared at him through his kitchen window. The jury of 7, this was a civil case, listened with expressions ranging from polite attention to visible bewilderment. One woman in the back row kept pressing her lips together in a way that might have been empathy or might have been suppressed laughter. It was hard to tell. Angela's cross-examination of Dennis took 11 minutes. She asked him, had a crow ever physically touched him? No. Had a crow ever entered his home? No. Had he received medical treatment for any crow-related injury? No. Had he contacted animal control? Yes. And what did they say? They said crows were a native species and there was nothing they could do. Then she asked him whether he was aware that birds had lived in the neighborhood before he moved there. He said, obviously, yes. She asked if he'd seen my bird feeder before purchasing the house. He paused, then said yes, he'd noticed it during the open house. Angela said nothing. She just let that sit with the jury. Angela put me on the stand, mostly just to let the jury see me. I told them about Roy, about the feeder he built, about the 30 years of Sunday mornings, about the birds I'd watched from my kitchen, the cardinals that came every spring, the chickadees that would eat from my hand if I was patient enough. Bellamy's cross-examination was cautious. He asked if I was aware that crows carried diseases. I said I was aware that many wild animals do. He asked if I'd considered my neighbor's concerns. I said I had, and that I was sorry about his car, and that I'd offered to buy him a car cover. He had no follow-up questions. Angela's one expert witness was a professor of ornithology from the state university. Dr. Merrick testified that crows are corvids with large territorial ranges, that they forage across areas of several square miles, and that a single bird feeder containing sunflower seeds has negligible impact on crow distribution in a residential area. The crows, he said, would be there whether my feeder existed or not. Bellamy tried to challenge him. Dr. Merrick responded with the patience of someone who had published 47 papers on corvid behavior and was not about to be argued with by a man in a bow tie who thought crows were vindictive. Richard Bellamy III gave a closing argument that lasted 25 minutes. He talked about property rights. He talked about quality of life. He talked about the principle of being comfortable in your own home. He got emotional about it, genuinely emotional, or a very good performance of it. He asked the jury to send a message about neighborly responsibility. I watched the jurors' faces. The woman who'd been pressing her lips together was doing it again. The man in the front row was looking at the ceiling. A younger woman was examining her fingernails. Whatever message Bellamy was trying to send, the jury's antenna wasn't picking it up. Angela's closing was 4 minutes. She said, Mrs. Hoffman has fed birds in her backyard for 30 years. It is legal to feed birds. Crows are wild animals that go where they choose. The plaintiff saw the bird feeder before he bought his house. His documented damages are $340. He is asking you for $750,000. She thanked the jury and sat down. I squeezed her hand under the table. She squeezed back. The jury never got to deliberate. After closing arguments, Judge Morrison called both attorneys to the bench. He spoke to them in low voices for 2 minutes. Then he addressed the courtroom. He said he was entering a directed verdict in favor of the defense. He said the plaintiff had failed to establish that the defendant's bird feeder constituted a legal nuisance under any recognized standard, and that the damages claimed were wholly unsupported by the evidence presented. Dennis stood up at his table like he'd been shocked. His mouth opened, but nothing came out. Bellamy put a hand on his arm. The judge wasn't finished. Judge Morrison looked at Dennis over his reading glasses and said, "And I'll remember this word until I die. Mr. Moyer, the common crow has inhabited this continent for approximately 2 million years. They were here before you. They will be here after you, and they do not require your neighbor's bird feeder as motivation to exist. This court is not in the business